All right, today we're diving into a single case that completely rewrote the rules for the Canadian justice system. It's called R versus Stinchcombe. Let's get right into it.
So I want you to imagine something. You're on trial, you're innocent, and you know for a fact that the prosecutor has a piece of evidence, a witness statement maybe, that could totally clear your name. But they decide to just not mention it, keep it buried in a file somewhere. It sounds outrageous, right? Well, before 1991 in Canada, that was a very real and very scary possibility. The way things worked back then was often called trial by ambush, and honestly, it's the perfect name for it. Defense lawyers would literally walk into a courtroom having almost no idea what evidence or witnesses the prosecution was about to spring on them. It was like a high-stakes poker game, except one side was basically blindfolded. The whole strategy was built on the element of surprise. The prosecution could keep all their cards hidden, then slam them on the table at the last minute, leaving the defense scrambling to respond. But after this case, that entire philosophy got turned on its head. The new rule? Full disclosure. No more surprises. The goal was to create a much, much more level playing field. So what was the case that caused this massive shift? Well, it all started with one man's fight. The person at the very center of all of this was William Stinchcombe. He was a lawyer himself out in Alberta, and he was facing some pretty serious charges for theft and fraud. Now, on the surface, it looked like a standard case, but it was about to become anything but. So here's how it all went down. During the police investigation, a really important witness, Stinchcombe's own secretary, gave a statement. His defense lawyer did what any lawyer would do and made a simple request. Hey, can we get a copy of that statement? And the Crown prosecutor said no, flat out refused. Their argument was basically, well, we're not planning on calling her as a witness, and we don't think her evidence helps our case, so you can't have it. That one single no kicked off a legal battle that went all the way up the chain to the Supreme Court of Canada. And so this case lands in front of the highest court in the country. The Supreme Court was now tasked with answering this huge, fundamental question about what fairness really means in a criminal trial. And in 1991, the Supreme Court of Canada handed down its decision. It was unanimous, and it was absolutely groundbreaking. It changed everything. The court basically redefined the entire job of a prosecutor. They said, look, your job is not just to get a conviction. Your primary duty is to the public, and that means making sure that justice is actually served. This was a massive philosophical shift away from that old win-at-all-costs mentality. Justice Sopinka, who wrote the decision for the court, put it perfectly. He said that all the evidence the police gather, the witness statements, the reports, all of it, that stuff isn't the property of the Crown. It's the property of the public. Its purpose is to get to the truth, not just to help one side win an argument. And out of this ruling, we got what's now known everywhere in Canadian law as the Stinchcombe rule. And it brought a whole new world of obligations for prosecutors. So what is it? Well, the Stinchcombe rule created the modern duty of Crown disclosure. It's a simple idea with huge consequences. The prosecution must give the defense all the relevant evidence it has. They have to actively hand it over, whether they plan to use it or not. In practice, it means the Crown and the police have to turn over everything relevant that they find. And this isn't just a one-time thing at the start of a case. If new evidence pops up in the middle of a trial, they have to share it right away. But here's the most important part, the real kicker. This applies even if the evidence completely destroys the Crown's own case. So what does all relevant information actually mean? Well, it means pretty much everything. Every single witness statement, the raw notes an officer scribbles in their notebook, expert forensic reports. It even includes things that could damage the credibility of a prosecution witness, like if they told a different story before. And most critically, it includes what's called exculpatory evidence. That's anything at all that might point to the accused being innocent. Okay, so why are we talking about a legal case from over 30 years ago? Why does this still matter so much today? Because it gets to the absolute core of what a fair trial is supposed to be. At the end of the day, you can't have a fair trial if one side is operating in the dark. You just can't. Justice can't be done if the defense doesn't even know the full case they're supposed to be fighting. This ruling basically turned on the lights for everybody in the courtroom. Before Stinchcombe, the power balance was totally out of whack. The state has enormous resources, police, labs, experts, and they held a huge, often unfair advantage. This ruling helped to rebalance those scales of justice. It gave the defense the tools they needed to properly challenge the prosecution's evidence and build a complete defense. It made the fight a whole lot fairer. And this isn't just some dusty old legal rule. The principles from this case are now considered a fundamental part of an accused person's rights under our Charter of Rights and Freedoms. It's tied directly to the right to make full answer and defense. It's a constitutional protection for every single Canadian.
But the story doesn't just end there in 1991. The principle is clear, but our modern world is throwing up some huge new challenges. What does full disclosure really mean today, when a single police investigation can generate terabytes of data from cell phones, social media, body cameras? The new problem isn't so much about the Crown hiding evidence anymore, it's about the defense getting buried in a digital avalanche. And that's the tough question that our courts are trying to figure out right now, how to make sure this vital, fundamental principle of fairness can keep up with our changing world.